Okay, well, good afternoon and welcome to this next presentation in our series of speakers this semester. I'm Dwight Newman, the chair of the Speakers Committee, and we're very fortunate to have with us today Professor Kent Roach from the University of Toronto Faculty of Law. If you know his background already, you know that a full bio could take away all his speaking time. So I'll mention just a few excerpts from his literally stellar record. Professor Kent Roach studied at the University of Toronto and at Yale. He served as a law clerk to Justice Bertha Wilson at the Supreme Court of Canada. Since 2002, he's been a Fellow of the Royal Society of Canada, a distinguished academic honour in keeping with his truly exceptional academic record. Professor Roach has authored around a dozen books, several of which have been shortlisted or been winners of some of Canada's most distinguished legal academic writing awards. He's published over 160 journal articles or book chapters. In addition to his academic work, he's contributed to a number of public inquiries and commissions, argued many times in the Supreme Court of Canada, and received a Lexpert Platinum Award for his pro bono work. As some of you know, Kent Roach is also a past dean of this College of Law, where he served a year as dean in the late 1990s. During his visit as a speaker on this trip, a gap in the college's historical record is being corrected, insofar as we've not had a formal decanal photo of Professor Roach on the wall. Some of you may have momentarily been distracted from your studies in the library this afternoon during his photo shoot activities. I hope he doesn't mind me saying, but I was a little bit distracted during the swimsuit shots. But in any case, tomorrow morning at 11 a.m., anyone who has a moment is welcome to attend the unveiling of his formal decanal photo on the wall of Dean's just outside the Dean's office upstairs, to be accompanied by some small snacks as we complete the historical record that wall contains. And Dean Sanjeev Anand, who's present in the audience today, will deliver some remarks at that time. In any event, this afternoon we have the immense privilege of hearing from one of Canada's foremost legal academics about some of his latest writing, looking back on 9/11 from 10 years after. In recent months, he's published with Cambridge University Press The 9/11 Effect, Comparative Counter-Terrorism, and he'll be speaking about related themes today. Please join me in welcoming Professor Kent Roach.
Thank you very much, Dwight, for that very generous introduction, at least apart from swimsuit stuff, which is horrifying to even think about. But anyway, it's very good to be back here, and I'd like to thank the college for, especially Dean Anand, for inviting me back. What I'm going to do today is talk about a book. Obviously, I can't cover an entire book in about 40 or 45 minutes because I want to leave time for questions. But I'm going to start out. The book covers, attempts to cover the decade after 9/11 and examining the effects of 9/11 in the United Nations and in 9 different countries. So I chose, I guess, the usual suspects of Western democracies, the United States, United Kingdom, Canada, and Australia. But I also thought it was very important to look at countries that had experienced terrorism before 9/11 and to some extent perhaps did not react quite as drastically to 9/11, although in a way the West caught up with those countries. And I'm not going to have much time to speak about those countries, but the other 5 countries are Syria and Egypt, which I got interested in through my work with the Arar Commission, Indonesia and Singapore, where I spent some time teaching and working on these matters, as well as Israel, which has been quite an influential jurisdiction post 9/11. But how I'm going to start off and how the book starts off is really looking at the United Nations. And I have to confess that as a domestic criminal and constitutional lawyer, I didn't really know an awful lot about the United Nations before 9/11. And indeed, for the first couple of years after, I don't think I was fully aware of the power that it was exerting on all member states with respect to the enactment of new counterterrorism laws. And so just before I start, I just want to give you, two little snapshots, because I think sometimes those of us who focus on domestic law ignore international law and international institutions at our peril. So as many of you know, shortly after 9/11, October 15th, 2001 to be exact, a large anti-terrorism law was introduced in the Canadian Parliament. And there was a very vibrant debate about that law, but it was enacted before the end of 2001. So the Liberal government at the time allowed some debate, but invoked closure to get the law through before the end of 2001. And one of the reasons why that law was enacted so quickly, but before the end of 2001, was the United Nations had in Security Council Resolution 1373, which is enacted under Chapter 7 of the UN Charter, so relating to international peace and security and mandatory on all member states, had created a new body of the Security Council called the Counterterrorism Committee, and all nations were instructed to file their first report with the Counterterrorism Committee on what they were doing about terrorism within 90 days. So an international reporting mechanism became in Canada, as well as in other democracies such as the United Kingdom, a de facto deadline for the enactment of extremely complex piece of legislation. So that's a historical reminder, I think, of how the UN has been very important in our counterterrorism law and policy. The second vignette I just wanted to start out with is in the next week or two, and I don't have any inside information, but it's expected that Parliament, that the government will introduce a bill in Parliament that will renew two of the more controversial features of the 2001 Anti-Terrorism Act, preventive arrests and investigative hearings. These were allowed to expire in 2007 in the minority parliament. And it's been rumored, and again, I don't have any inside information, I think I might be the last to know, but it's been rumored that that bill will include a new offense relating to the indirect advocacy, or sometimes referred to as the glorification of terrorism. Now, there has been a law like this enacted in England in the wake of the 2005 London bombings. But again, if that comes to pass, you may hear some debates about UN Security Council Resolution 1624, which was enacted after the London bombings, largely at Prime Minister Blair's behest, in order to call upon all nations to enact laws against the indirect advocacy or glorification of terrorism. So these are, just by way of preliminary, two kind of concrete examples of how I think all of us who may focus more on domestic law and policy need to be aware of some pretty powerful international and transnational drivers of policymaking. So let's talk about the UN's response to 9/11. As I mentioned, Security Council Resolution 1373 was enacted in the Security Council in New York City, literally while the fires were still burning in the rubble of the World Trade Center. And if you read Security Council Resolution 1373, you will see that that there's an emphasis on terrorism financing. So kind of job number one after 9/11 at the Security Council seemed to be calling upon nations to enact laws against terrorism financing. And indeed, I think that that was probably the best justification that the Canadian government gave for its post-9/11 legislation, because we did not have any terrorism financing laws on the book. Of course, we had murder attempts and conspiracies and the like. Why did the Security Council focus on terrorism financing? Well, you know, when countries or the United Nations, and many have characterized Security Council Resolution 1373 as legislation, as international legislation, precisely because it was enacted under Chapter 7. But when legislatures and governments respond to emergencies, they do so quickly and they grab what is at hand. And the most recent international convention was directed at terrorism financing. Indeed, under Security Council Resolution 1267, which you may know better as the UN blacklisting or terrorist listing process, which was, of course, enacted before 9/11, the UN had, under Chapter 7, again, in Security Council Resolution 1267, put an asset and travel freeze ban first on the Taliban and later on those associated with bin Laden and al-Qaeda. So even though before 9/11 there was an asset freeze and a travel ban, and that failed to stop 9/11, which is probably the most expensive act of terrorism in history. The 9/11 Commission found that it cost a little under $500,000 to finance the 9/11 plot. The Security Council kind of immediately, before they knew about that funding, emphasized the issue of terrorism financing. And I'm going to talk a little bit later about how, in my view, the terrorism financing regime is problematic, both from a rights perspective, because it involves listing people as associated with al-Qaeda on the basis of secret intelligence that they don't see, and indeed not even all members of the Security Council may see. But it's also problematic, in my view, from a security perspective, because it is based on the assumption that by blocking the funds that are used, that we can prevent acts of terrorism. And of course, the acts of terrorism that we have seen since 9/11 have thankfully not been as drastic, but whether it's the London, Madrid, Mumbai bombings, these are things that can be financed, as indeed in Canada, the Air India bombing in 1985, which was the world's most deadliest act of aviation terrorism before 9/11, they can basically be financed on someone's credit card. It costs less than $20,000 to put on very deadly acts of terrorism. So Security Council Resolution 1373 emphasized terrorism financing. It also, perhaps more sensibly, emphasized the need to exchange intelligence and exchange information between countries in order to prevent acts of terrorism. Now, I think that that was an understandable result. 9/11 was largely a failure of intelligence, although much within the domestic American system. But we also need to recall that this exchange of information in the months after 9/11 led to inaccurate information being given from the RCMP to the Americans that likely played a role in Mayor Arar's rendition to Syria, where he was subsequently tortured. Security Council Resolution 1373 also looked to immigration law as a form of anti-terrorism law. So warned states that they should make sure that refugee status was not abused by terrorists. And many countries, Canada, the United Kingdom especially, look to immigration law as a principal form of anti-terrorism law for years after 9/11. Well, I think there's some interesting questions about whether the UN, which is supposed to be an international body, should look so much at immigration law, which is kind of all about deflecting someone who might be a terrorist to someone else. Not our problem. The use of immigration law also led to issues about departures from criminal law standards of fairness, specifically the use of secret evidence. And then finally, the Security Council Resolution 1373 called on all nations, or really demanded that all nations enact laws against terrorism and terrorism financing without in any way trying to define what terrorism is. Now, obviously, the definition of terrorism is a vexed issue, but in my book, I argue that this was a missed opportunity that the UN had in those immediate days after 9/11 to agree on a restrained definition of terrorism, such as the Supreme Court of Canada read in to an undefined definition of terrorism in our immigration law in the Suresh case. That was a general definition of terrorism, in fact, taken from the 1999 convention. And the UN did not, the Security Council did not promote that definition after 9/11, fearing that this would lead to the definitional quagmire that indeed the international community has been in before and after 9/11. So Security Council Resolution 1373 was a fundamental starting point for nation states responding to 9/11. And in my view, it had some serious flaws, both from a perspective of human rights and from a perspective of security. Indeed, the only mention of human rights in Security Council Resolution 1373 was with respect to the use of immigration law. And this really got to a dilemma that I don't think really any nation has solved, of what do you do with a non-citizen who is in your territory, who may be a terrorist, but if you deport him back to his country of citizenship, i.e. Syria, for example, that person will be tortured. So the only mention of human rights in Security Council Resolution 1373 was to the law against refoulement, or deportation to torture, but it really identified a dilemma without in any way solving it. So, as I said, the listing process and really the whole idea of terrorism financing will not work unless you have a list. Because the whole idea of terrorism financing laws is we rely upon our financial institutions as the main enforcement mechanism in terrorism financing laws. They are the ones who are supposed to freeze someone's account and alert the authorities. So the very idea of terrorism financing really depends upon lists of people that can then be distributed to the financial institutions. There's all kinds of technical problems, logistical problems with those lists, with the use of aliases, with the use of names that are common, particularly in the Arab and Muslim world. And so the focus on terrorism financing really has a kind of due process problem embedded in it, that terrorism financing will not work unless there are lists. And the listing process is an example of the use of secret intelligence as evidence in order to impose legal consequences on individuals in the form of an asset freeze and a travel ban. Now, as you know, in Canada, through the story of Abdelrazek, Abusian Abdelrazek, there have been many challenges, not only in Canada, but in the European Court of Justice and in British courts and other courts, to the listing process that is used by the UN. And there's been a range of resolutions adopted, and as you may know, Abusian Abdelrazek was recently delisted by the 1267 Committee upon a recommendation by an ombudsperson, Judge Kimberly Prost, who is a Canadian, and he is now off the 1267 list. So the UN Security Council, I think to its credit, has tried to respond to some of these due process challenges. But this really, the reform process really only started in 2008. And the listing process of 1267 still does not resemble a criminal process. So if you accept that 1267 listings imposes criminal sanctions on people, then we're at a situation where the country that is responsible for listing most people, namely the United States of America, is not going to disclose the full intelligence that is behind that listing. And if you look at the 1267 listing process, you'll see that they have narrative summaries that explains why people like Mr. Abdelrazek was listed. But the problem with the narrative summaries is it does not contain, and for obvious reasons, any of the sources or the methods that were used to obtain the intelligence. So Mr. Abdelrazek's narrative summary, for example, said he was an associate of Abu Zubaydah, but it doesn't say who said he was an associate of Abu Zubaydah. Did not say Abu Zubaydah said this, and maybe he said this after he was waterboarded for the 50th time. So there is a real problem with listing from a rights perspective. And I would also submit from a security perspective, because one of the things that we've seen, and I think this will accelerate with the death of bin Laden, is Al-Qaeda has evolved from a central organizing group into something which is much more, I think, akin to an ideology. So, for example, if you look at the Toronto terrorism prosecution, even the Momin Khawaja prosecution, the Canadian prosecutors could not rely upon the listing process in order to say this person is associated with a terrorist group. That the terrorist group is kind of an ad hoc group that is created by radicalization and is not something that is going to be well caught through the listing process. So, you know, I'm very critical of the emphasis on terrorism financing. I think it has both human rights problems and it's not likely to be very effective in dealing with a second generation terrorist challenge. Yet it is embedded in laws literally throughout the globe. Now, as I said, the UN has really failed to offer any guidance about the proper definition of terrorism until 2004 in Security Council Resolution 1566. But by that time, it was certainly too late to matter in the many countries, such as Canada, that had enacted new counter-terrorism laws. Now, there are some that are very pessimistic about the idea that we will ever agree on a definition of terrorism. And there tends to be two things that people fixate on. One is the freedom fighter the Nelson Mandela sort of issue. When Nelson Mandela was here right after 9/11 to receive honorary citizenship, someone asked him about it, and he said, "You're a terrorist if you lose," which was pithy, to say the least. So there's the problem of freedom fighters, and there is the problem of state terrorism. On the issue of definition, I'm actually much less skeptical. I think something like the definition that the Supreme Court adopted from the 1999 Financing Convention in Suresh can work, and it can work by limiting both the state terrorism and the freedom fighter exceptions or freedom fighter problems to the law of war. That is, if you define terrorism as the intentional killing of non-combatants outside of an armed conflict, I think you capture what happened on 9/11, whether it was the attack on the World Trade Center or indeed the attack on the Pentagon. And to me, if we are going to have a global counterterrorism regime, if we're going to have laws that the Security Council really requires each state to pass against terrorism, as a basic matter of legality, we have to have some guidance on the proper definition of terrorism. If we simply leave it to each country to define terrorism as they want, then there is a real danger that they will define terrorism in a way that is, molded to perhaps targeting domestic opposition. Again, that may not be an issue in the Western democracies, but it is a real issue in countries like Syria. And one of the things that I found really quite disturbing in my research was reading the country reports of repressive regimes to the Counterterrorism Committee. And they were basically, as indeed former President Mubarak said, they were basically saying, look, now that you guys, the powerful West, have experienced terrorism, you're coming around to our way of thinking. And it was almost using the UN process as a means to launder quite repressive laws. Now, in the absence of any international guidance in Security Council 1373 with respect to the definition of terrorism, many countries, including our own, look to the British Terrorism Act 2000. And this was indeed really the template for many countries as they tried to define terrorism, often for the first time in their criminal laws. And the Terrorism Act 2000 has a very broad definition of terrorism, indeed broader than we have now in Canadian law, including all property damage, all interference with electronic systems, and really focusing on the issue of political or religious motive. And that, of course, was challenged in our Kawaja case and has subsequently been upheld by the Ontario Court of Appeal, and there's an appeal pending in the Supreme Court of Canada. But my point here is that that the British definition is much broader than any international best efforts. And so the many countries that look to Britain really have now created counterterrorism laws that are much broader than any international definition that might, in my view, hopefully one day win some approval. Now, the British influence, I have a colleague who read the book, and one of his comments was, man, the Brits are all over this. The British influence in counterterrorism law is extremely important. So not only was the Terrorism Act 2000 the most influential a template for post 9/11 terrorism laws. When I was in Indonesia, especially the young Indonesians would listen to me and says, you know, looks like an American, sounds like an American. Are you going to bring us the Patriot Act to Indonesia? And my frank response is I couldn't bring you the Patriot Act even if I wanted to, and trust me, I wouldn't want to, because the American system is so idiosyncratic that it doesn't travel very well, whereas the British system has traveled very, very well. And so post 9/11, we see modern Britain having a huge influence on many countries, particularly in the Commonwealth. But we also see colonial Britain having a huge impact. So if you go to countries like Singapore or Israel even, that use administrative detention as an alternative to the criminal law, the roots of those administrative detention regimes lie in British colonial emergency legislation. And so one of the things that I found post 9/11 is that countries like Singapore used 9/11 as a way to re-legitimate and repackage their Internal Security Act, which was inherited from British colonial rule and allows for indeterminate detention on the basis of secret evidence and without trial, and repackaged that both to the UN and to its own population as a form of counter-terrorism law. So Britain is obviously a country that has, of all the Western democracies, probably experienced the most with terrorism and has probably had the greatest impact. Another example of the British impact, which we may be seeing very soon in Canada, is this emphasis on speech associated with terrorism. The Brits had a tradition of doing that. Those of you who might remember the IRA crisis will know that for a long time the British government prohibited certain speech associated with the IRA. You couldn't show a person who said he was a spokesperson of the IRA on British television. After the London bombings, Britain also went back to this tradition of criminalizing speech associated with terrorism in terms of the Terrorism Act 2006, which is, as originally proposed, called for the criminal prohibition on any speech that glorified any act of terrorism in the past. The government eventually had to back away from that, but it still has a very broad law against not only the direct advocacy of terrorism, but the indirect advocacy of terrorism, which is seen as a form of praise of an act of terrorism anywhere in the world in a manner that would suggest that that act should be emulated today. And I think it's a very interesting question that we will see answered in the next couple of months in Canada, whether Canada goes down this route and to what extent we will borrow from the British definition. And the British definition comes from, at least in my view, a European concept of militant democracy, which is partly recognized in Article 17 of the European Convention. But the problem is, regardless of whether that works in Britain or in other parts of Europe, when it is embraced in Security Council Resolution 1624, it has to be applied to all 192 countries of the UN. So you have a concept of militant democracy being used in countries that are frankly not very democratic. Now, the UN is not a unified force, and one of the things that I found in working through this material is the UN is, in fact, really quite fractured. And so although the Security Council and its Counterterrorism Committee was really focused on security issues, there are various rights protection bodies within the UN, of which I'm sure you're familiar. The Office for the High Commissioner on Human Rights is probably the most famous. And really, from the start, they continued to urge the Security Council, and particularly the Counterterrorism Committee, to pay more attention to human rights. The initial response in 2003 and 2004 was, that's not our business. Human rights is another side of the UN. The Security Council has, to be fair, since 2006, taken more cognizance of human rights, as there's been a recognition, I think, that violations of human rights may even be counterproductive solely from a security perspective. But for the first few years after 9/11, the Security Council and its Counterterrorism Committee operated as virtually a rights-free body. Now, where was the General Assembly during all of this? The General Assembly, which represents, the Security Council, of course, represents 15 countries, including the 5 with vetoes. The General Assembly was largely missing in action. And it was only in 2006 that the General Assembly agreed on a global counterterrorism strategy. And this counterterrorism strategy, to me, seems like a fairly balanced counterterrorism strategy, in that it addresses not only measures to prevent terrorism, but also issues related to conditions conducive to terrorism, building capacity, and respect for rights and the rule of law. But much like the Security Council's guidance on the definition of terrorism, I fear that the General Assembly's strategy comes a little bit too late. But it is there, and I think it is a pretty sound and balanced strategy. Now, in my book, I talk about some countries that really didn't do very much to respond to 9/11. Singapore, I've already talked about in terms of its Internal Security Act. Egypt, obviously, that's a changing situation as of events that started almost a year ago today. But in Egypt, you saw reliance on emergency rule, special courts. You saw President Mubarak basically saying that the U.S.'s policy of extraordinary rendition to Egypt affirmed the wisdom of Egypt's approach to terrorism. In Israel, Israel's a very interesting case, because you see systems of administrative detention that were used in the Second Intifada, starts in 2002. These pre-exist. That they're used extensively. Again, that allows the use of secret intelligence. And you also see targeted killing. So administrative military detention and targeted killing, very much countermeasures that the United States has been attracted to. But one of the differences in Israel is, as some of you may know, the Israeli courts have extremely broad standing rules, and they have no political questions doctrines of non-judiciability. So whether you agree or not with where Israel comes out on these issues, most of these, administrative detention and targeted killing, are subject to judicial review and judicial challenges. The United States has very much, I think, borrowed from Israel, but they have a legal system that is much more restrained when it comes to review of executive action. So, for example, the targeted killing case that you're probably familiar with in the United States, the Al-Waki case, where his father tried to litigate in federal court against his targeted killing, was denied on a variety of bases by the U.S. courts. First, they said a father doesn't have standing to challenge the targeted killing of his son, which is a little bit of a narrow standing doctrine. Second, they said targeted killing may be a political question that's reserved for the executive. And thirdly, they said even if you got over those hurdles, we have a very broad doctrine of state secrets, which would probably preclude the litigation. So there are, I think, some interesting parallels between the Israeli and the American approach to counterterrorism, the increased emphasis on the military and targeted killing. But there's some interesting differences between the legal systems of those two countries. Now, you've heard much about the Patriot Act. My view of the Patriot Act, when it's read in its comparative perspective, is that it's relatively mild. The Patriot Act does not, in my view, impinge on human rights, especially expressive and associational rights, nearly as much as the Terrorism Act 2000 does. And Americans are always astonished to hear that, and they wonder if I've become an apologist. But I'm not, because I think the most important thing about the Patriot Act was not what the Patriot Act authorized, but what it didn't authorize. The Patriot Act became a symbol in the United States, a civil liberties symbol that was opposed by both those on the left and the right. But the real action was outside the Patriot Act. So there's nothing in the Patriot Act about preventive detention. But what the United States did in the wake of 9/11 is they used grand jury material witness warrants as a de facto form of preventive detention. Similarly, there's nothing in the Patriot Act, as there was in our Anti-Terrorism Act, about expanding the ability of signals intelligence agencies to intercept communications that have one end in a foreign country and another end in the domestic jurisdiction. That was done through a program that was authorized by a memo from John Yoo, who is most famously known as one of the authors of the so-called torture memos. So in the United States, we find that much of the more drastic counterterrorism measures fit into what I describe as a pattern of extra-legalism. And what do I mean by extra-legalism? Extra-legalism, to me, is the use of law to achieve extra-legal ends. And I make an argument that the American legal system, particularly through its narrow standing, broad political questions, and broad state secrets doctrine, uses law basically as a resource to say we are not going to review conduct that that elsewhere might very well be viewed as extra-legal. And of course, you see this extra-legalism in the failure, the nearly universal failure of all the civil suits in the United States that have come, whether it's to the abuse of material witness warrants, whether it's to the use of warrantless spying through the National Security Agency, or whether it was through the extraordinary rendition program. So Mayor Arar's civil claim in the United States was dismissed by a divided Second Circuit, but was dismissed. So there is, I think, a story of American exceptionalism, but it is a story that law is deeply embedded in. I think it is an important warning, as indeed the torture memos were for us who are lawyers, about the danger of law being used essentially as cover for extralegal conduct. Now, there was the Detainee Treatment Act, which was in part a response to Abu Ghraib, but also attempted to limit habeas corpus. And now we have the Military Commissions Act, and most recently, the military detention provisions. So again, many other countries have moved away from these alternatives to the criminal law. I think both in Canada and in Britain, we are seeing a move back to relying upon criminal prosecutions as the primary response to terrorism. There are many terrorism prosecutions in the United States. By all accounts, they have a high conviction rate, but the U.S. still seems very, very much committed to models of military detention and military trials, at least with respect to non-citizens. I've already talked about the United Kingdom. I've mentioned the Terrorism Act 2000. Despite having a kind of state-of-the-art Terrorism Act at 9/11, the UK enacted another major piece of counterterrorism law in 2001, again, like in Canada, within the 90 days. The focal piece of that legislation derogated from fair trial rights, or overrode fair trial rights under the European Convention. And of course, in the Belmarsh case in 2004, the House of Lords said that derogation from fair trial rights to allow the indeterminate detention of non-citizens suspected of terrorism who could not be returned to countries like Syria or Egypt because they would be tortured was both disproportionate and discriminatory. And so the UK, with some bumps like the use of control orders, and most recently now terrorism prevention measures, seems to be moving a little bit back towards relying on criminal sanctions. In Canada, we've had the Anti-Terrorism Act, but that was not used until 2004 when the Khawaja prosecution was started, and instead we had the security certificates. So much like Britain, we relied upon immigration law as counterterrorism law, and as you're no doubt familiar with, there's been all sorts of litigation about security certificates. Two of them have been have been abandoned or quashed, and we have put more of an emphasis on criminal prosecutions. In security certificates, we saw this flight away from crime, but I would suggest if you compare the reactions to the security certificate cases, including those that remain, to the Toronto terrorism prosecutions, it shows, I think, that if possible, it is much better to provide a full criminal trial, and that is seen as a much fairer process, where the security certificates have been both legally and politically controversial, to say the least. One of the things that I'd like to just quickly mention before I conclude, and that is one of the things that I think Canada did, which was fairly ahead of the curve, but reveals a continuing problem with whole of government responses to terrorism that we've seen since 9/11 is the appointment of the Arar and then subsequently the Yakabuchi inquiries to provide some form of accountability for the exchange of intelligence that led to the torture of Mayor Arar and 3 other Canadian citizens in Syria. One of the reasons why public inquiries had to be appointed in both of those cases is that there is no one review body that has a jurisdiction to look at CSIS, the RCMP, Customs, and the Department of Foreign Affairs. In order to have accountability for whole of government responses to terrorism, you need to have agencies that have broad review mandates. And so for various reasons, Canada appointed these public inquiries. Similar public inquiries have been appointed in Australia, and one recently in the UK has been appointed, but the government just announced last week that they would effectively suspend the operation of the UK inquiry, which was in many ways similar to the Mayor Arar inquiry in that it would look at policing, intelligence, and foreign affairs conduct to see if Britain had been complicit in terrorism. And so one of the concerns that I have as we move forward is one of the responses to 9/11, which I think is generally sensible, has been that governments have tried to break down the walls between separate agencies and have a whole of government response to a very serious terrorism threat. The problem is that while the security agencies have been busy busting out of their silos, the review agencies still remain mired in their silos. So if you have a joint CSIS RCMP operation, which we have in all of our major cities with the integrated national security teams, you cannot do integrated review. And so one of the things that I fear is that we have a kind of double accountability gap as we move forward to the next decade of counterterrorism. Double accountability in the sense that the domestic agencies do not have jurisdiction to look at all of the domestic agencies that are involved in counterterrorism. And of course, the UN or some similar international agency does not have really any jurisdiction to look at transnational terrorism investigations. So the Arar Commission, for example, asked the US and Syria to participate in the Commission of Inquiry. It comes as no surprise that both governments declined that invitation. And so one of the things that worries me most as we move forward is that we have pervasive accountability gaps both at the domestic and at the international level. And I'll just conclude that lack of accountability for me is a matter both of human rights and security. So I kind of reject the idea that we have a dichotomy between human rights and security. In some cases, we may have a need for balance and a need for proportional limitation. But with respect to accountability, I fear that the accountability gaps will impinge both our respect for human rights, which is something that I saw during my work with the Arar Commission, but also will not allow effective review of the efficacy of our counterterrorism efforts, how CSIS and the RCMP cooperate, for example, which was something I was very concerned with when I spent 4 years working on the Air India Commission. And so my hope is that as we move forward in the next decade, we will find some ways to plug these accountability gaps. Thank you very much. I'd be happy to take any questions. Yes?
Yes, I wonder if you could say something more about what is looming on the horizon. You said we might be hitting the British form of indirect
Yes.
advocacy, ban on that, not ban, but
Yep.
law against it, and glorification.
Yes.
I'd like to know if you have visualized who is going to be hit with it here. What kind of advocacy are we talking about? What is glorification? Is
Yep.
it just a positive review or so if
Yep.
you could concretize that so
Yep.
we know
Well,
what is coming.
that's right. Well, the fear or the possibility is that someone who makes a kind of radical extremist speech expressing sympathy for some form of terrorism committed in, Kashmir, Israel, somewhere else, might be prosecuted for indirect advocacy of terrorism. Now, I mean, it's hard to say because we don't know whether the government's even going to include it. It's been rumored that it is going to be included. But one of the reasons why I'm skeptical about criminalization of speech associated with terrorism is I think that there's a real danger that it plays into a clash of civilizations sort of thesis, which is actually part of the narrative of Al-Qaeda. Now, having said that, I'm not, I hope, naive about the threat. And so one of the things that I've seen really throughout the world is that we've taken intelligence concepts and we've put them into law, and we've put them into criminal law. So I actually, subject to restraints, have no particular problems for CSIS or other people having surveillance with respect to extremists if there is a reasonable ground to believe that they may be involved with threats to the security of Canada. But the problem is when we take an intelligence concept, like, say, watch listing, which is also an intelligence concept, and we essentially entrench it in the criminal law without the safeguards and the due process safeguards that are associated with the criminal law. So I see the focus on extremist speech as an offense, as another example of taking a concept that may make sense within the world of intelligence and putting it into our, in this case, perhaps criminal law. Yes?
Yes, Professor, you talk about monitoring conversations. As I understand, correct me if I'm wrong, under the Patriot Act, there's certain provisions that allow the state to monitor solicitor-client conversations that go on.
Yes.
How is that, obviously that's in the United States, not Canada. How is this terrorism going to affect, these terrorism laws going to affect me in Canada? For instance, if a terrorist comes to me and tells me that he has committed a terrorist act, not that he's about to, I understand if they're about to commit a crime, we have to reveal that information as lawyers, but if they tell me that they have committed a crime, am I going to have to report that to the state? Can I advise my client on what to do? While I'm advising my client what to do, does that mean I'm participating in terrorism? How are these things going to affect that relationship?
Yeah. Well, I mean, you are right that I don't think it was in the Patriot Act, but it was under regulations enacted at the same time that provided for forms of monitoring solicitor-client conversations in American prisons. I'm not aware that we have anything like that in Canada. And although I was critical, and I remain critical of parts of our anti-terrorism law when they were enacted, as I look at the laws of other countries, they are more restrained. They're certainly more restrained than British and Australian law, which is even more closely followed the British model. So, I mean, I don't think that there's really any worry right now that a person who is representing someone accused of terrorism is going to be prosecuted as a terrorism. There's a number of safeguards, one of them being the Attorney General has to agree to any form of terrorism prosecution. So I don't see that as an immediate concern. Yes?
You started speaking about terrorist financing.
Yep.
And I'm just wondering if you think there's any kind of legislative, anything that could be done legislatively to deal with Hawala financing.
Yeah, well, no, I mean, certainly many countries have tried to expand terrorism financing laws and reporting laws under money laundering laws to informal systems. And so I think that our terrorism financing laws have also been amended and expanded. So I think it is possible for Hawala financing to be legally covered. Whether people are going to report and whether those reporting is going to reveal any actionable intelligence, I think is another matter. So if you look at the annual reports of FinTrack, and one of the problems with terrorism financing, which I really didn't have time to go into, is essentially terrorism financing has been grafted onto a money laundering model. And the two things are fundamentally different. Money laundering is about taking large amounts of dirty money and trying to make it